Welcome everyone. This is What Are the Steps in Buying a Law Firm Part 2. So following on from our last point, which was asking good questions to get information about the law firm you're looking at, we're now talking about meeting or talking to the vendor principal. Can you elaborate a little bit, Peter?
That's right, Stan. So this is what I consider to be step 5 out of 10 steps. And this step is about meeting the vendor principal. And how do you make the most of your time in the short amount of time that you get to have this personal meeting, or it could be an online meeting? Well, I think the two most important things to ascertain in such a meeting is this the sort of person that you think you can work with ongoing, at least maybe for 2 years or more? And also try to understand what the motivations are of the vendor in selling the practice. You want to hear something credible that you can understand, that's specific. General statements like, oh, well, I've had enough and I want to do something else. I think you need to dig a bit deeper if that's what you're told in relation to motivations for selling.
Okay, so we meet or talk with the vendor principal, and the prospect, next step, analyze financials, get a bit deeper into the financials, yeah?
And like in that first meeting with the vendor, I really discourage talking about financial aspects. I believe that's a waste of time, valuable time, because you can always obtain the financials, and then that's the next step, ideally. Step 6 is to analyze them. So look at the trends over time, understand the trends in revenue and expenses, and then put a series of questions down in an email, for example. Try to put all of your questions in the one email so that you don't ask about one line item and then 3 days later another line item. Try to get all of your questions down at the one time. Make it an efficient process. That's what we said in part 1 of this video, how to make this an efficient process.
That's great. And I suppose if the prospect then wishes to continue, they've looked at the financials, they've had a meeting with the vendor, then we can get into some healthy negotiation, right? So what would be your tip in terms of a healthy negotiation?
Well, healthy is a good word. And essentially all of these steps, the whole process it's a bit of a trust building process between the purchaser and the vendor. It's a trust building process. So that's why the negotiations, yes, you can have negotiations and make sure that you are looking after your own interests, but you can't negotiate to the extent of turning a healthy relationship into an unhealthy relationship and breaking down the trust between the parties. So it's very different to buying a property, a house, for example, where you probably will never see the vendor ever again. There's no ongoing relationship there. It's very different in buying a professional services firm where there is going to be a period of time where you have to work together and cooperate. So yes, healthy negotiations.
Right. And then finally, hopefully everyone agrees on terms. And I suppose that's where we become useful, very useful in terms of getting the agreement finalised. And then there's the due diligence process. What's your recommendations in terms of due diligence?
Well, due diligence, that's a term that means so many different things to different people. But I find that when it comes to buying law firms, that there's usually a lot less involved in due diligence than maybe buying other types of businesses. In fact, most of the analysis and investigation that you've already done probably forms 95% of your due diligence. If you're given financial statements which are not externally prepared by an accountant, it might be a good idea to get BAS statements. But certainly, I don't think that you should expect to do some onerous examination of bank statements. Although if you are so inclined, why not? That's not going to hurt, except if you have the time. But coming back to the key terms where you and I will help the parties, I think what I want to emphasize here is that we want to agree on the key terms. So we have to understand what the key terms are, and that's where our advice will come into the equation, is to ascertain what the key terms are and make sure that there is a consensus on those key terms. And so then once that's done, then that will be fed into the actual contract.
Right. And that's the final step, really, isn't it? Is asking for a contract, preparation of contracts and exchange of contracts.
That's right.
In terms of the contract, there is a contract of sale. There's also quite possibly a consultancy agreement. Is that right, Peter?
Exactly. And I think the consulting agreement terms are part of the key terms which need to be agreed to. So we do the draft contract, and we're dealing with lawyers, so we don't have to tell lawyers how to do their own business. I'd say maybe 50 to 60% of lawyers will engage an external lawyer, even though they are lawyers themselves, but may not be necessary. We're keeping it simple as possible, and exchange of contracts is step 10, the final step, but it's not the end of the story. It's probably the beginning of the story, the beginning of the journey.
Thanks, Peter. That's great.